contract is one which no man in his sense, not under delusion, would make, on the one hand, and which no fair and honest man would accept on the other. The right of a minor to disaffirm his contract is based upon sound public policy to protect the minor from his own improvidence and the overreaching of adults. Generally, the law presumes that the parties to a contract have the requisite contractual capacity to enter into a contract. However, certain persons do not have the capacity. They include minors, insane persons, and intoxicated persons. Both the common law of contract and many state statutes protect persons who lack contractual capacities from having contracts enforced against them. The party asserting incapacity, his or her guardian, conservator, or other legal representative bears the burden of proof. An essential element for the formation of a contract is that the object of the contract be lawful. A contract to perform an illegal act is called an illegal contract. Illegal contracts are void in ab initio non pro tunc, not voidable, but are wholly, entirely void from their inception. That is, they cannot be enforced by either party to the contract. The term illegal contract is a misnomer. However, since no contract exists if the object of the contract is illegal, in addition, courts hold that unconscionable contracts are unenforceable. An unenforceable contract is one that is so oppressive or manifestly unfair that it would be unjust to enforce it. Capacity to contract and the lawfulness of contracts are discussed in this chapter. Minors, a person who has not reached the age of majority. Minors do not always have the maturity, experience, or sophistication needed to enter into contracts with adults. The common law defines minors as females under the age of 18 and males under the age of 21. In addition, many states have enacted statutes that specify the age of majority. The most prevalent age of majority is 18 years of age for both males and females. Any age below the statutory age of majority is called period of minority. Infancy doctrine. A doctrine that allows minors to disaffirm, cancel most contracts they have entered into with adults. The infancy doctrine. To protect minors, the law recognizes the infancy doctrine, which allows minors to disaffirm or cancel most contracts they have entered into with adults. A minor's rights to disaffirm a contract is based on public policy. The reasoning is that minors should be protected from unscrupulous behavior of adults. Under the infancy doctrine, a minor has the option of choosing whether to enforce the contract, i.e., the contract is voidable by a minor. The adult party is bound to the minor's decision. If both parties to the contract are minors, both parties have the right to disaffirm the contract. If performance of the contract favors the minor will probably enforce the contract. Otherwise, the contract will probably be disaffirmed. However, a minor may not affirm one part of the contract and disaffirm another part of the contract. In most states, the infancy doctrine is an objective standard. If a person's age is below the age of majority, the court will not inquire into his or her knowledge, experience, or sophistication. Disaffirmance. The act of a minor to rescind a contract under the infancy doctrine. Disaffirmance may be done orally, in writing, or by the minor's conduct. Disaffirmance. A minor can expressly disaffirm a contract orally, in writing, or by a minor's conduct. No special formalities are required. The contract may be disaffirmed at any time prior to reaching the age of majority plus a reasonable time. The designation of a reasonable time is determined on a case-by-case basis. Duties of restitution and restoration. If the minor's contract is executory and neither party has performed, the minor can simply disaffirm the contract. There is nothing to recover since neither party has given the other party anything of value. However, if the parties have exchanged considerations and partially or fully perform the contract at the time the minor disaffirms the contract, the issue becomes one of what consideration or restitution must be made. The following rules apply. Contempt party's duty of restitution. If the minor has transferred consideration, money, property, or other valuables to the competent party before disaffirming the contract, that party must place the minor in status quo. That is, the minor must be restored to the same position he or she was before the minor entered into the contract. This is usually done by returning the consideration to the minor. If the consideration has been sold or has depreciated in value, the competent party must pay the minor the cash equivalent. This is called the competent party's duty of restitution. Competent party's duty of restitution. If a minor has transferred money, property, or other valuables to the competent party before disaffirming the contract, the party must place the minor in status quo. Minor's duty of restoration. Generally, a minor is obligated only to return the goods or property he or she has received from the adult in the condition it is in at the time of disaffirmance, subject to several exceptions discussed later in this chapter. This is so even if the item has been consumed, lost, destroyed, or depreciated in value at the time of the disaffirmance. This is called the minor's duty of restoration. This rule is based on the rationale that if a minor had to place the adult in status quo upon disaffirmance of a contract, there would be no incentive for an adult not to deal with a minor. Most states provide that a minor must put the adult in status quo upon disaffirmance of the contract if the minor's intentional or grossly negligent conduct caused the loss of the value to the adult's property. A few states have enacted statutes that require the minor to make restitution of the reasonable value of the item when disaffirming any contract. This is called the minor's duty of restitution. Misrepresentation of age. On occasion, minors might misrepresent their age to an adult when entering into a contract. Under the common law, such a minor would still have the right of disaffirm the contract. Most states have changed this rule in recognition of its unfairness to the adults. These states provide that minors who misrepresent their age must place the adult in status quo if they disaffirm the contract. In other words, a minor who has misrepresented his or her age when entering into a contract owes a duty of restoration and restitution when disaffirming it. Consider this example. Sherry, a minor, misrepresents that she is an adult and enters into a contract to purchase an automobile costing $20,000 from Bruce, a competent adult. Mr. Ruffino delivers the automobile after he receives payment in full. The automobile later sustains $7,000 worth of damages in an accident that is not Miss McNair's fault. In order to disaffirm the contract, Miss McNair must return the damaged automobile plus $7,000 to Mr. Ruffino. Ratification. Oh, skipped one. Business brief. A business should require a customer to prove that he or she is an adult if there is doubt as to the age. This practice is extremely important concerning major purchases. Ratification. Business brief. Many businesses, such as car dealerships, require a minor's parent or another competent adult to co-sign the contract before they will sell an item to a minor. Ratification. If a minor does not disaffirm a contract either during the period of minority or within a reasonable time after reaching the age of majority, the contract is considered ratified, accepted. This means that the minor, who is now an adult, is bound by the contract. The right to disaffirm the contract has been lost. Note that any attempt by a minor to ratify a contract while still a minor can be disaffirmed, just as the original contract can be disaffirmed. Ratification. The act of a minor after the minor has reached the age of majority by which he or she accepts a contract entered into when he or she was a minor. The ratification which relates back to the inception of the contract can be by express oral or written words or implied from the minor's conduct. Ergo, after reaching the age of majority, the minor remains silent regarding the contract. The following necessaries of life. Necessaries of life. A minor must pay the reasonable value of food, clothing, shelter, medical care, and other items considered necessary to the maintenance of life. Necessaries of life. Minors are obligated to pay for the necessaries of life that they contract for. Otherwise, many adults would refuse to sell these items to them. Although there is no standard definition of what is a necessary of life, items such as food, clothing, shelter, medical services, and the like are generally understood to fit this category. Goods and services such as automobiles, tools of trade, education, and vocational training have also been found to be necessaries of life in some situations. The minor's age, lifestyle, and status in life influence what is considered necessary. For example, necessaries for a married minor are greater than for an unmarried minor. The seller's recovery is based on the equitable doctrine of quasi-contract rather than on the contract itself. Under this theory, the minor is obligated only to pay the reasonable value of the goods or services received. Reasonable value is determined on a case-by-case basis. Parents' liability for their children's contracts. Generally, parents owe a legal duty to provide food, clothing, shelter, and necessaries of life for their children. Parents are liable for their children's contracts for necessaries of life that they have not adequately provided. The parental duty of support terminates if a minor becomes emancipated. Emancipation occurs when a minor voluntarily leaves home and lives apart from his or her parents. The courts consider factors such as getting married, setting up a separate household, joining the military services, and the like in determining whether a minor is emancipated. Each situation is examined on its merits. Emancipation when a minor voluntarily leaves home and lives apart from his or her parents. Mentally incompetent persons. Insanity vitiates all acts. Mental incapacity may arise because of mental illness, brain damage, mental retardation, senility, and the like. Senility, and the like. The law protects people suffering from substantial mental incapacities from enforcement of contracts against them because such person may not understand the consequences of their actions in entering into a contract. To be relieved of his or her duties under a contract, the law requires a person to have been legally insane at the time of entering into the contract. This is called legal insanity. Most states use the objective cognitive understanding test to determine legal insanity. Under this test, the person's mental incapacity must render that person incapacitated. Legal insanity as a state of contractual incapacity as determined by law. Render that person incapable of understanding or comprehending the nature of the transaction. Mere weakness of intellect, slight psychological or emotional problems or delusions do not constitute legal insanity. The law has developed the following two standards concerning contracts of mentally incompetent persons. Adjudged insane. Adjudged insane, a person who has been adjudged insane by a proper court or administrative agency. A contract entered into by such person is void. Adjudged insane. In certain cases, a relative, loved one, or other interested party may institute a legal action to have someone declared legally, i.e., adjudged insane. If after hearing the evidence at the formal judicial or administrative hearing, the person is adjudged insane, the court will make that person a ward of the court and appoint a guardian to act on that person's behalf. If a person has been adjudged insane, any contract entered into by that person is void. That is, no contract exists. The court's appointed guardian is the only one who has legal authority to enter into contracts on behalf of the person. I'll talk about adjudged insane by the court system a little bit later on because they don't have any grounds to make medical determinations. They're not psychologists. They're not mental health doctors. So them making medical decisions is an issue. All right. Okay. Insane but not adjudged insane. Insane but not adjudged insane. A person who is insane but has not been adjudged insane by a court or administrative agency, a contract entered into by such person is generally voidable. So there's a difference now. Insane but not adjudged insane, their contracts are voidable. They're not void, they're voidable. It means they could be void if proven adjudged insane. Some states hold that such a contract is void. Insane but not adjudged insane, and no formal ruling has been made. If no formal ruling has been made, any contracts entered into by a person who suffers from a mental impairment that makes him legally insane are voidable by the insane person. Unless the other party does not have contractual capacity, he does not have the option to avoid the contract. Some people have alternating periods of sanity and insanity. Any contracts made by such a person during a lucid interval are enforceable. Contracts made while the person was not legally sane can be disaffirmed. A person who has dealt with an insane person must place that insane person in status quo if the contract is either void or voided by the insane person. Most states hold that the party who did not know he was dealing with an insane person must be placed in status quo upon avoidance of the contract. Insane persons are liable in quasi-contracts to pay the reasonable value for necessaries of life they receive. Intoxicated person. A person who is under contractual incapacity because of ingestion of alcohol or drugs to the point of incompetence or impairment. Most states provide that contracts entered into by intoxicated persons are voidable by that person. The intoxication may occur because of alcohol or drugs. The contract is not voidable by the other party if that party had contractual capacity. Under the majority rule, the contract is voidable only if the person was intoxicated when the contract was entered into, that he or she was incapable of understanding or comprehending the nature of the transaction. In most states, this rule holds even if the intoxication was self-induced. Some states only allow the person to disaffirm the contract if the person were forced to become intoxicated or did so unknowingly. The amount of alcohol or drugs that are necessary to be consumed by a person to be considered legally intoxicated to disaffirm contracts varies from case to case. The factors that are considered include the user's physical characteristics and his or her ability to hold intoxicants. A person who disaffirms a contract based on intoxication generally must be returned to the status quo. In turn, the intoxicated person generally must return the consideration received under the contract to the other party and make restitution that returns the other party to status quo. After becoming sober, an intoxicated person can ratify the contracts he or she entered into while intoxicated. Intoxicated persons are liable in quasi-contracts to pay the reasonable value for necessaries of life they receive. Illegality. Contracts contrary to statutes. Both federal and state legislators have enacted statutes that prohibit certain types of conduct. For example, penal codes make certain activities crimes, antitrust statutes prohibits certain types of agreements between competitors, and so on. Contracts to perform an activity that is prohibited by statutes are illegal contracts. Usury law. A law that sets an upper limit on the interest rate that can be charged on certain types of loans. Usury laws. State usury laws set an upper limit on the annual interest rate that can be charged on certain types of loans. The limits vary from state to state. Lenders who charge a higher rate than the state limit are guilty of usury. The primary purposes of these laws is to protect unsophisticated borrowers from loan sharks and others who charge exorbitant rates of interest. Most states provide criminal and civil penalties for making usurious loans. Some states require lenders to remit the difference between the interest rate charged on the loan and the usury rate to the borrower. Other states prohibit lenders from collecting any interest on the loan. Still, other states provide that a usurious loan is a void contract, permitting the borrower not to have to pay the interest or the principal of the loan to the lender. Most usury laws exempt certain types of lenders and loans transactions involving legitimate business transactions from the reach of the law. Often these exemptions include loans made by banks and other financial institutions, loans above a certain dollar amount, and loans made to corporations and other businesses and such. Gambling statutes. Gambling statutes, statutes that make certain forms of gambling illegal. Many states have amended gambling laws to permit state-operated lotteries. Gambling statutes. All states either prohibit or regulate gambling, wagering, lotteries, and games of chance. States provide various criminal and civil penalties for illegal gambling. There is a distinction between lawful risk shifting contracts and gambling contracts. For example, if property insurance is purchased on one's own car and the car is destroyed in an accident, the insurance company must pay the claim. This is a lawful risk shifting contract because the purchaser had an insurable interest in the car. However, insurance purchased on a neighbor's car would be considered to be gambling. The purchaser does not have an insurable interest in the car and is betting only on its destruction. There are many exceptions to wagering laws. For example, many states have enacted statutes that permit games of chance under a certain dollar amount. Bingo games, lotteries, conducted by religious and charitable organizations and the like. Many states also permit the regulate horse racing, harness racing, dog racing, and state-operated lotteries. Sabbath laws. Certain states have enacted laws called Sabbath laws, Sunday laws, or blue laws that prohibit or limit the carrying on of certain secular activities on Sundays, except for contracts for the necessaries of life, charitable donations, and such. These laws generally prohibit or invalidate exculpatory contracts that are entered into on Sunday. Many states do not actively enforce these laws. In some states, they have even been found to be unconstitutional. Contracts to commit a crime. As mentioned previously, contracts to commit criminal acts are void. If the object of a contract became illegal after the contract was entered into because the government enacted a statute that made it unlawful, the parties are discharged from the contract. The contract is not an illegal contract unless the parties agree to go forward and complete it. Licensing statutes. All states require members of certain professions and occupations to be licensed by the state in which they practice. Lawyers, doctors, real estate agents, insurance agents, certified public accountants, teachers, contractors, hairdressers, and such are among them. In most instances, a license is granted to persons who demonstrate that they have the proper schooling, experience, and moral character required by the relevant statute. Sometimes a written examination is also required. Problems arise when an unlicensed person tries to collect payment for services provided to another under a contract. Some statutes expressly provide that unlicensed persons cannot enforce contracts to provide these services. If the statute is silent on the point, enforcement depends on whether it is a regulatory statute or a revenue-raising statute. Regulatory statutes, licensing statutes enacted to protect the public are called regulatory statutes. Generally, unlicensed persons cannot recover payment for services that regulatory statutes license persons to provide. Consider this example. State law provides that legal services can be provided only by lawyers who have graduated from law school and passed the appropriate bar exam. Nevertheless, Maria Swieger, a first-year law student, agrees to draft a will for Randy McCabe for a $150 fee. Since Ms. Swieger is not licensed to provide legal services, she has violated a regulatory statute. She cannot enforce the contract and recover payment from Mr. McCabe. That could be argued. Article 1, Section 10, the government can't impede with the private obligation of contract. That right there could be destroyed. Anyway. Just want to show you that not everything you read in a book is 100% absolute. Revenue-raising statute. Licensing statutes enacted to raise money for the government are called revenue-raising statutes. A person who provides services pursuant to the contract without the appropriate license required by such statute can enforce the contract and recover payment for services rendered. For example, suppose a state licensing statute requires licensed attorneys to pay an annual $200 license fee without requiring continuing education or other new qualifications. A licensed attorney who forgets to pay the fee can enforce contracts and recover payments for the legal services he or she renders. That is because the statute merely gathers revenue. Protection of the public is not a factor. Illegal contracts contrary to public policy. Now, this is something you really want to pay attention to. Contracts contrary to public policy, especially after 1933. Contracts that have a negative impact on society or interfere with public safety and welfare. Certain contracts are illegal because they are contrary to public policy. Such contracts are void. Although public policy eludes a precise definition, the courts have held contracts to be contrary to public policy if they have a negative impact on society or interfere with public safety and welfare. Immoral contracts. The law relating to public policy cannot remain immutable. It must change with passage of time. The wind of change blows on it. Immoral contracts. Immoral contracts, that is, contracts whose objective is the commission of an act that is considered immoral by society, may be found to be against public policy. For example, a contract that is based on sexual favors has been held an immoral contract, void as against public policy. Judges are not free to define morality based on their individual views. Instead, they must look to the practices and beliefs of society when defining immoral conduct. Contracts in restraint of trade. This is another one you're really going to want to pay attention to. The general economic policy, remember, against public policy, the general economic policy of this country favors competition. At common law, contracts in restraint of trade, that is, contracts which unreasonably restrain trade, were held to be unlawful. For example, it would be illegal restraint of trade if all the bakers in the neighborhood agreed to fix the price of the bread they sold. The baker's contract would be void. Covenants not to compete. The sale of a business often includes a goodwill or repudiation. To protect this goodwill after the sale, the seller often enters into an agreement with the buyer not to engage in a similar business or occupation within a specified geographical area for a specified period of time following the sale. This agreement is called a covenant not to compete, or a non-compete clause or non-compete agreement. Employment contracts often contain non-compete clauses that prohibit an employee from competing with his or her employer for a certain time period after leaving the employment. Non-compete clause, an agreement whereby a person agrees not to engage in a specified business or occupation within a designated geographical area for a specific period of time following the sale. Covenants not to compete that are ancillary to a legitimate sale of a business or employment contracts are lawful if they are reasonable in three aspects. 1, the line of business protected, 2, the geographical area protected, and 3, the duration of the rest of the restriction. A covenant that is found to be unreasonable is not enforceable as written. The reasonableness of a covenant not to compete are examined on a case-by-case basis. If a covenant not to compete is unreasonable, the courts may either refuse to enforce it or change it so that it is reasonable. Usually the courts choose the first option. And so if you enter into a non-compete agreement, or somebody enters into a non-compete agreement with you, and then they violate that, it's called tortious interference, okay? And it grants rise to a claim. Consider this example. Suppose Stacy Rogers is a certified public accountant, CPA, with a lucrative practice in San Diego, California. Her business includes a substantial amount of goodwill. When she sells her practice, she agrees not to open another accounting practice in the state of California for a 50-year period. This covenant not to compete is reasonable in the line of business protected, but is unreasonable in the geographical scope and duration of time. It will not be enforced by the courts as written. The covenant not to compete would be reasonable and enforceable if it prohibited Miss Rogers only from practicing as a CPA in the city of San Diego for 5 years. A covenant not to compete that is not ancillary to a legitimate business transaction is void as against public policy because the non-compete clause is not protecting a legitimate business interest. Also, the other reason that it's against public policy is because it interferes with trade and commerce, and when you're interfering with trade and commerce, you're interfering with tax dollars, and that's how they float the United States government. So they want you guys to be working. Get out there, you little slaves, and work to the fucking bone. For example, a contract where one lawyer paid another lawyer not to open an office nearby would be void as against public policy because it is not ancillary to a legitimate business transaction. Business brief. Non-compete clauses are often used in sales of businesses to preserve the goodwill of the business for the new owner. Without a non-compete clause, the seller could open next to the buyer and serve previous customers. So that's all it's about, making sure, because when you're buying a corporation, you're buying the clientele, and if you're dumb enough to allow the guy that you're buying the company from to open up shop next to you, and he's going to move all his clientele over there, and then you just bought a shell corporation essentially, and will not see a return on your investment. All right, exculpatory clauses. Exculpatory clause is a contractual provision that relieves one or both parties to the contract from tort liability for ordinary negligence. An exculpatory cause is a contractual provision that relieves one or both parties to the contract from tort liability. Exculpatory clauses can relieve a party of liability for ordinary negligence. They cannot be used in situations involving willful conduct, intentional torts, fraud, recklessness, or gross negligence. Exculpatory clauses are often found in leases, sales contracts, ticket stubs to sporting events, parking lot tickets, service contracts, and the like. Such clauses do not have to be reciprocal, i.e., one party may be relieved of tort liability while the other party is not. Generally, the courts do not favor exculpatory clauses unless both parties have equal bargaining power. The courts are willing to permit competent parties of equal bargaining power to establish which of them bears the risk. Consider this example. Jim voluntarily enrolled in a parachute jump course and signed a contract containing an exculpatory clause that relieved the parachute center of liability. After receiving proper instruction, he jumped from the airplane. Unfortunately, Jim was injured when he could not steer the parachute towards the target area. He sued the parachute center for damages, but the court enforced the exculpatory clause, reasoning that parachute jumping did not involve an essential service and that there was no decisive advantage in bargaining power between the parties. Exculpatory clauses that either affect the public interest or result from superior bargaining power are usually found to be void as against public policy. While the outcome varies with the circumstances of the case, the greater the degree that the party serves the general public. While the outcome varies with the circumstances of the case, the greater the degree that the party serves the general public, the greater the chance that the exculpatory clause will be struck down as illegal. The courts will consider such factors as the type of activity involved and the relative bargaining powers, knowledge, experience, and sophistication of the parties. Exculpatory causes are void as against public policy if they either, one, affect public interest, or two, result from the superior bargaining power of the party asserting the clause. Effect of illegality. Since illegal contracts are void, the parties cannot sue for non-performance. Further, if an illegal contract is executed, the court will generally leave the parties where it finds them. Exceptions to the general rule. Certain situations are exempt from the general rule of the effect of finding an illegal contract. If an exception applies, the innocent party may use the court system to sue for damages or to recover consideration paid under the illegal contract. Persons who can assert an exception are: 1. Innocent persons who were unjustifiably ignorant of the law or fact that made the contract illegal. For example, a person who purchases insurance from an unlicensed insurance company may recover insurance benefits from the unlicensed company. 2. Persons who are induced to enter into illegal contracts by fraud, duress, or undue influence. For example, a shop owner who pays $5,000 protection money to a mobster so that his store will not be burned down by the mobster can recover the $5,000. 3. Person who entered into an illegal contract withdraw before the illegal act is performed. For example, if the president of New Toy Corporation pays $10,000 to an employee of Old Toy Corporation to steal a trade secret from his employer, but reconsiders and tells the employee not to do it before he has done it, the New Toy Corporation may recover the $10,000. And 4. Persons who were less at fault than the other party for entering into an illegal contract. At common law, parties to an illegal contract were considered in peri del isito, in equal fault. Some states have changed this rule and permit less at fault parties to recover restitution of the consideration they paid under an illegal contract from the more at fault parties. Unconscionable contracts. The general rule of freedom of contract holds that if 1. The object of a contract is lawful, and 2. The other elements for the formation of a contract are met, the court will enforce a contract according to its terms. Although it is generally presumed that parties are capable of protecting their own interest when contracting, it is a fact of life that dominant parties sometimes take advantage of weaker parties. As a result, some lawful contracts are so oppressive and manifestly unfair that they are unjust. To prevent the enforcement of such contracts, the courts developed the equitable doctrine of unconscionability, which is based on public policy. A contract found to be unconscionable under this doctrine is called an unconscionable contract, or a contract of adhesion. Unconscionability, a doctrine under which courts may deny enforcement of unfair or oppressive contracts. The courts are given substantial discretion in determining whether a contract or contract clause is unconscionable. There is no single definition of unconscionability. The doctrine may not be used merely to save a contracting party from a bad bargain. Elements of an unconscionable contract. The following elements must be shown to prove that a contract or clause in a contract is unconscionable. 1. The parties possessed severally unequal bargaining power. 2. The dominant party unreasonably used its unequal bargaining power to obtain oppressive or manifestly unfair contract terms. And 3. The adhering party had no reasonable alternative. In other words, the dominant party must misuse its great power to obtain oppressive contract terms from the adhering party, and the adhering party must prove that it could not reasonably refuse to accept those terms. This is often proven by showing that the oppressive terms are contained in standard contracts used industry-wide. Caution. Unconscionability is extremely subjective. This doctrine does not change the general rule that parties are free to make a bad bargain. Only unconscionable contracts are unenforceable. Remedies for unconscionability. If a court finds that a contract or a contract clause is unconscionable, it may 1. Refuse to enforce the contract, 2. Refuse to enforce the unconscionable clause, but enforce the remainderment of the contract, or 3. Limit the applicability of any unconscionable clause so as to avoid any unconscionable results. The appropriate remedy depends on the facts and circumstances of each. Note that since unconscionability is a matter of law, the judge may opt to decide the case without a jury trial.